trust, but they don't really understand why that might be or really know if that is actually the right thing for them. And part of that stems from the fact that people don't understand how these documents work or when they might need to be used, or when they are being used, how they actually function. In some cases, many people come in thinking, oh, can't you just beneficiary designate everything as well? Isn't that as simple as it can be, and that nothing can go wrong with that because it just pays out to these individuals? So welcome. I'm attorney Justin Randall here with Hooper Law Office. Today we're talking about wills and trusts and the difference between them and really why you might use them one over the other as the central focal point of your estate plan, and kind of the process that each one uses. If you are participating via Zoom, just to let you know that you can ask questions as I'm going through this. So there's a Q&A function that I have up on my screen here, and I can see as you ask questions. So if anything comes up, please feel free to submit it and I will answer it as we go along. Another thing, if you're participating via Zoom, you will receive the feedback form that we send out from this that then allows you to give any feedback or any topics you might want to hear more information on, but also it gives you a spot to fill out that you would like an initial consultation as well. Those are complimentary initial consultations. They don't cost you anything to come talk to us. They are usually scheduled for about 2 hours. Sometimes they take way less time. Sometimes they take way more time. It just kind of depends on the topic at hand and the discussions being had. But if anything we talk about today is going to or creates any concern for you or makes you want to get some more information, that's a really good way to let us know that you'd like us to reach out to set something up, is to fill out that form and say that you would like us to reach out. Okay. And I guess one last thing is our topic next week is actually going to be about common caregiver mistakes. So if you have any sort of family members or family friends or just loved ones in general that you are likely going to need to care for at some point, or are currently caring for, or even know of somebody who is caring for a loved one or a relative, it's a really good topic because there's a lot of things that caregivers do that thinking that they're relatively harmless or that they're the right thing to do, that when it comes to long-term care can create a lot of issues, unnecessarily and unintentionally, is the most tragic part of it. Is it's not intended to create a problem, but it still does. So that is our topic next week. But today we're talking about wills and trusts as the focal point of estate plans and when you might use one as the central document in your plan over the other. Today, because we've talked about this in the past and I wanted to kind of tweak a little bit how I talked about it, is more with the process that each document would use so that you can really see how that would function and how it functions during your lifetime, how it functions after one of you has passed. That will really kind of show you what that looks like and why you might need to use one over the other. So to start, a really common thing, unfortunately a common thing, is people come in with neither a will or a trust. And this is this is not to shame anybody, it's just a very common thing. And they generally have on their accounts beneficiary designations, meaning payable on death on a bank account or transfer on death. In that, when that occurs, those payable on death or transfer on death designations, those avoid probate. So people often have heard about probate as this sort of, I call it kind of the boogeyman of estate planning, right? People hear that term and they immediately think it's, you should avoid it at all costs. And that's not necessarily true. It depends on what your goal for your estate is. But people hear about it and they just think they should avoid it no matter what. So hearing that beneficiary designations avoid probate, people often use those as the center point of their plan. And I use center point kind of loosely because it's really not one controlling thing. It's on each account. And the problem that this creates is not that it doesn't avoid probate. That part of the goal is accomplished, is that it's not really a plan. It doesn't provide a central point to that plan where one person has access after you've passed away to pay final expenses. It doesn't provide any sort of contingencies for what happens if something goes wrong, if a beneficiary who's inheriting from you has any sort of supplemental needs or is on any sort of means-based government benefits. those sorts of things. It does not account for those because it just pays out to that individual or transfers to that individual. And in particular, this creates issues where, there might be someone with a substance abuse issue that couldn't have been foreseen. So direct control over any funds like that could be dangerous to them. Or for somebody who has a child with supplemental or special needs that has any sort of means-based benefits from the government, when they themselves are directly listed as a beneficiary on those accounts, it pays to them or it transfers to them in terms of ownership. So if they are limited in what they are allowed to have in terms of qualifying for their programs that they might be receiving assistance from, then putting money in their name directly is a bad thing because it can cause them to lose those benefits and ultimately cause more harm than good. Now, I'll talk about why this doesn't mean you have to disinherit those people either. There are alternatives to doing, leaving something to someone directly in a way that it can still benefit them, but without the negative side effects of just leaving money to somebody in that situation. But beneficiary designations by themselves do not provide for this because they are direct transfers to the beneficiaries listed on those accounts. So if you just leave it to that person, you're not accounting for anything that could go wrong in the process, without utilizing a different estate planning tool. And I don't mean to harp too much on beneficiary designations because they are incredibly valuable tools to use, but they are not by themselves a plan. So they are parts of a plan and can be used to get the end result that you want as part of your plan. But when you are relying solely on them, you are not providing a well drafted plan for your family to follow. One of the last things I'll mention quick here about beneficiary designations is in some of the issues that can come up is we'll often see people list the personal representative or the executor of their estate as the initial beneficiary so that in their minds they have the money to pay for final expenses and then they're relying on that person to dole out the funds after all those expenses are paid by the terms of the will. However, the problem with that is, one, you are not actually guaranteeing that that person is under any obligation to split the funds the way you've intended. When you leave it to somebody, it's their money, which means that they can do whatever they want with it at that point. They are not, if they are the beneficiary and are not in sort of a fiduciary role as a personal representative for an estate, for example, then they are not under the obligation to use your estate funds the way you intended because now they are the owner. So it's not a good idea to expect someone to follow the terms of the will or follow the terms of your estate plan as a beneficiary, trying to split up the funds. There are better ways that you can have someone have access to funds and still pay for final expenses before doling out the money the way you want. In a way that, one, they're then obligated to follow the plan, and two, does not mean, you're opening it up, and this is a big concern, you're not opening it up to their own liabilities. As I mentioned earlier, if someone is the direct beneficiary on something, that's now their money, and if they are, that personal representative you've named has any sort of ongoing creditor concerns, divorce concerns, lawsuit liability concerns, leaving money to them as an individual rather than to your estate where they are in charge of that estate, you're opening it up to those sorts of concerns. So this is where people then say, well, what about my will? I have a will that, puts this person in charge and says they have to follow the distribution the way I intended, here, equally to all my kids. I'll use as an example because that tends to be the most common. Well, what people don't understand is when you have a will, your will only controls the assets that are going through the probate process. So if you have a will and you think you're avoiding probate just by having a will in general, unfortunately, that's not how the wills work. They are a list of instructions to the probate court to follow of how you want your estate to be divided up, who you want in charge of that estate. If you have minor children, who you want as guardians for your children if something happens. That's what wills do. So if you don't have your assets going through probate, say you have everything with a payable on death or a transfer on death designation on those accounts, but then you intend to use your will, because all of those beneficiary designations are avoiding probate, the will is not going to control those assets. So if you intend to use the will as the center point of your plan, you should also intend to have some amount of your estate, at the very least, go through the probate process, and go directly to the estate, so that the personal representative, in their capacity as the personal representative, has access to those funds to pay final expenses, before anybody gets any of their share, to make sure that those expenses are shared equally then. And then, as the personal representative of that estate through that will, they are not the owner of those assets. They could also be a beneficiary, but that's something that can come up after their role as a personal representative. But as a personal representative, they are themselves not the owner of those assets, meaning if, say I'm somebody's personal representative and I'm handling an estate, and then suddenly I get sued as me, the individual, well, those assets that are in that person's estate that I'm the representative for are not subject to any of my own personal liabilities then. So it can really make sure that, one, you're not opening up funds to one person's liabilities. If you have a will and you are intending for the will to be followed, you want to send some of these assets through probate. But it also makes sure that the person you've put in charge is they have a obligation to follow that will, to dole out the estate the way you've dictated. So, to the extent possible, assuming the facts, and there's still money left to dole out, right? Creditors always still have the first sort of right to a lot of these assets with somebody's estate. So using a will means that, as the focal point of your plan, means you are intending somewhat to use the probate process. It doesn't mean everything will go through probate, because there are still some assets you don't want to send through someone's probate estate. For example, certain types of, retirement accounts, IRAs, 401ks, things like that should not be sent through the probate process due to the terms of those plans and sort of the payout provisions that can be triggered when you give it to what's called a not a designated beneficiary, which is essentially an individual, right? So if you leave it to someone's estate, you could trigger a 5-year payout for those accounts. But those are more of an exception than the actual rule of sending things through probate. If it's just a cash account, it's real estate, life insurance, things like that, you might want to go through probate if you're using a will, so that your personal representative has access to them, to those funds to pay for expenses. Now, how probate tends to work with a will. If someone is nominated as a personal representative in the will, that does not mean it's an automatic appointment. You're not guaranteeing that person will be named. They will weigh that nomination very heavily in favor of that person, unless somebody comes up with a really good reason not to have them appointed, like, hey, they're committing fraud, or they are completely incapacitated and can't act, something like that. But it is still a nomination. So when somebody has a will, they can't just, if they're named as the personal representative, they can't just take that will down to the bank and say, hey, I'm the personal representative. You do still have to submit it to probate first. And then if you are the personal representative, the court will approve you after, everyone has been given notice and given a chance to object if they will, or otherwise just sign off on it. And then once you are approved as the personal representative, or in this case, if your personal representative is approved, you can, they take what's called a domiciliary letter, which is granted by the court to show, the bank or whomever that, hey, I am who I say I am. I have been appointed by the court, so I can act as that personal representative. That's how you make sure that they have access to those funds. It's not to give them the money right away as a beneficiary, because then they're not obligated to use it how you intended. So it's not an immediate thing when someone is appointed as a personal representative. It still takes a little bit of time, but it makes sure that it's handled the way that it should be under the law and the way you intended in your will. So as I did sort of briefly mention as well, a will is where you need to nominate guardians for your minor children. You can't do that, in a trust, for example. I've seen people put that in a trust language before, but that doesn't make it binding in any way. The court is where they have to approve those guardians, because they have an interest to make sure that those children, those minor children, are taken care of properly then. So if you're using a will, that means you are intending to use the probate process. And I have mentioned a couple already, but there are a few really good reasons for some people to use probate as the process to handle their estate, and why they might need to use a will. One I mentioned already was if you have minor kids, regardless of whether the will is the controlling document for your assets, that is where you're going to name guardians for your children. So we have plenty of clients who are using a trust as the basis for their estate plan, but still nominate the guardians in the will. And it may be a very limited probate if something were to happen to them, but that is where those guardians are named. So minor children is one of the main reasons why somebody would want to have some level of probate occur. Another one is if you have what's called a deficit estate. That is another really common reason why somebody might want to use probate. Deficit estate meaning that you owe more money than your net worth when you pass away. So it sort of functions like a bankruptcy then after someone passes away. It gives the creditors a place to come forward, make sure all those claims are paid to the extent they can be, and it may mean that the family doesn't get there's nothing for the family to receive after that point, depending on the situation, but it is the proper way to handle it under the law. And the personal representative has an obligation to also make sure that that is handled properly as well. So that's another really good reason. Sometimes as well, there are certain types of trusts that you can only set up through a will for a beneficiary, especially with long-term care planning. So there's another reason why we might actually want to go through probate for somebody, is to set up that trust for that individual. It's called a spousal supplemental needs trust, a testamentary spousal supplemental needs trust for certain types of long-term care planning. So some reasons why somebody might want to go through probate. There's a lot of reasons why people don't, for example. So probate tends to take about a year to a year and a half to fully complete. So the length of time is a big reason why people don't generally want to go through it. Expense is another big reason why somebody might not want to go through probate. It tends to be more expensive for someone's estate rather than avoiding probate or using a trust as the basis for a plan. And part of that is attorney's fees, it's filing fees, because probate tends to be more work. So it tends to be more expensive too. It doesn't mean you don't use it. It just means that is one of the reasons why somebody would like to avoid it. Is kind of a very common concern that we hear. Another really big concern for people with probate, depending on family situations, is that probate is actually public record. So somebody could go down to the court while a probate is ongoing and see, okay, here's, the assets of the estate. Here's what, who the beneficiaries of that will are, And so this can be a really big concern when there's minor children, for example, who are where there's money going through that estate and just going out to a minor beneficiary's, inherited trust, or maybe a young adult. This is where you hear about like kind of the predatory investors, saying, hey, I'm an investor, I can help you, grow that money. And then unfortunately taking advantage of people. So if privacy is a really big concern for you, then probate is also not the right tool, because there's just no controlling that kind of public nature of it. It's not like they're just making public notice of it necessarily, just saying, hey, here's, John Smith's estate size in the newspaper or anything like that, or posting it on Facebook, but it still is available for someone to request records on. So if privacy is a big concern, then that is, probate might not be the right tool for you to use for your estate. So if you don't want to use beneficiary designations as a plan in of themselves, because they're not really a central point of control, or they don't really provide a lot of backup plans for if something goes wrong, but they avoid probate. So you like that aspect of them, but you also want kind of the benefit of what a will gives you, where it provides, or nominates somebody to be in charge of the estate, to pay for those expenses out of the pooled funds from your estate, but still also provides probate avoidance and backup plans. how do you get the best of those both worlds? Well, that's where trusts tend to come in. And trusts are, in terms of how the estate gets divided up, are very similar to what a will might say. Here's the percentage I want each person to get. Here's the specific distributions and of property that I might want somebody to get. But because they are not subject to the probate court, they're privately administered. That means that it provides that same sort of structure that a will might provide in terms of control of the estate for one person to pay all the final expenses. It provides that benefit with a way to avoid probate as well. So they are privately administered, meaning they're not public record when they're being administered. So that privacy concern is sort of eliminated with a trust, assuming that somebody doesn't just post the language of the trust online or something like that. I mean, that would be not a good idea for that trustee to do. One of the big benefits of administering a trust after someone passes away, I mentioned when someone is nominated as a personal representative, it's not necessarily an immediate appointment. You still have to be approved by the court. When somebody nominates what we in this case would call a successor trustee, somebody to take over that trust as an administrative duty after someone has passed away, is they don't have to be approved by anyone other than you, right? You are the person nominating them and you are naming them as the successor trustee. There's no court involvement, so that means there's no one to approve them other than yourself. So you can guarantee that person will be able to act. You don't have to, if you especially are concerned about any family members who might have bad, kind of bad blood amongst themselves, just objecting to someone's appointment to, cause a problem, then a trust is a really good tool because there's nowhere for them to object. That person is the trustee. So you can really you have a lot more control over what happens after you've passed with a trust than you might with a will, in terms of like who's in charge and preventing people from creating problems. So that's where that successor trustee is. You don't have to wait for an appointment either. There's no real time gap there because the trust itself should say, when I pass away or when the survivor of my spouse and I pass away, John Smith is the trustee. That person is the trustee at that point. So there's nobody to have to submit that to. It's just they are the trustee, and the terms of the trust dictate that. So there's no real sort of time delay in that person acting, or at least much less significant of one, depending on, if they have the trust in front of them, right? They might still need to locate it. So that kind of delay is much quicker or is much shorter in that period of time. Trust administration as a whole tends to take less time overall. You're looking more at like 6 months rather than a full year to a year and a half. And it does tend to be less expensive overall for the estate. So because trust administration takes less time, because it's less work on the attorney's part, if you're having an attorney help you with that, then they tend to charge less for it, quite frankly. So it tends to be cheaper for someone's estate to go through a trust administration using a trust as the focal point of your estate plan than it would be using probate, for example, just because there's less time involved. It's generally much kind of more clean cut and smoother of an administration at that point. The one waiting period of time with a trust is still you have to give proper public notice to potential creditors to make sure that they have the legal notice they're owed to come forward and make a claim against the estate. But other than that, it's kind of on the trustee's sort of own schedule, which you obviously want to appoint someone then who is good at scheduling things and getting things done in a timely manner. That's still important. The other thing I mentioned that beneficiary designations don't really do, but a will or a trust can do for you, is making sure that people are protected in terms of, if they have any sort of substance abuse concerns or just general responsibility concerns, or are receiving any sort of means-based government benefit. So for example, somebody on Medicaid, you don't want them to just inherit money as individuals. You want a certain type of planning set up for them. And you can do this both through a will and a trust. But if you're trying to do this while avoiding probate, then in a trust, you would want to provide certain contingencies that say, if any of our beneficiaries have any of these circumstances, substance abuse, maybe behavioral concerns in terms of like, are they really bad at managing money, or do they have any sort of supplemental needs we need to take care of that would otherwise prohibit them from just inheriting as themselves. There are provisions you can put into those plans that are triggered if that occurs, and say that that person can still inherit from you, but they are not available for their creditors, for divorce, for lawsuit liabilities. They can't be counted against them for means-based benefits if they're inheriting in what's called a supplemental needs trust, for example. So this provides a way for people with children with special needs to actually still leave them something for their care to supplement their benefits, right? So those are things you can do through a will and a trust. Whether you use a will as the plan or you use a trust as the focal point of your plan is going to really depend more on what process you intend to use after you've passed away. So I did just get a quick question here. Can you appoint more than one person as a trustee in a trust? Yes. Actually, pretty commonly, I wouldn't say every time, but pretty commonly we'll have co-trustees, especially if it's only a couple siblings, say, and they get along really well and they work well together. Then it can be a really good idea to appoint co-trustees, because the way I would tend to do it, for example, is saying that they don't both have to agree on everything necessarily, but that they each have independent authority to act, so that they can sort of delegate duties. They don't both have to be signing all of the documents all the time. And so that kind of sharing of that duty can actually make it a lot less of a burden on that one individual then. You don't ever want too many co-trustees. I mean, there is such a thing in this case as too many people acting at once. So the most I've done, I think, was 3 people acting. I wouldn't want to go above that, but you can have co-trustees. You can place restrictions on there of like, do they all have to agree? Although, in terms of just how smoothly that's going to operate, if you have any concerns about, sort of checks and balances, it's almost better not to have too many people as trustee. But you can name co-trustees. For example, if you are married and you do a joint revocable trust, you and your spouse are actually co-trustees. So you can have as many trustees as you want, I suppose, but you kind of want to talk with your attorney who is helping you draft that plan to make sure that you are not kind of overdoing it, or that there aren't other concerns about who is actually being named as a co-trustee. And of course, one of the most important things that I mentioned there is that if the co-trustees don't like each other, that could be a huge problem. You want them to work well together. So with trusts, then trusts are kind of a good combination of a will and beneficiary designations, in that they still give you that central point of control. They still provide a way to pay expenses before beneficiaries are given any money. But they also avoid probate. So it is a big reason why a lot of people would want to use a trust over a will. When you have a trust, you still do have a will. So that is a common question I get. It's just that when you have the trust as the basis for your plan, all your will is really there to do is to say, if something happened to go through probate because it wasn't properly funded to the trust or titled in the name of the trust when I pass, then it kind of points it back to where it should go. Now, if you're using your will and you have or as part of the estate administration after someone's passed, but they had a trust as their plan, it does mean that something wasn't kind of allocated properly to that trust during lifetime. So one of the most important things to keep in mind with a trust in particular is that if you are using a trust for the basis of your estate plan, that you have it properly funded. And by funded, I mean titling accounts in the name of that trust while you're alive, getting any real estate in the name of the trust. If you have sort of like an LLC ownership interest, like you own a rental company, maybe make sure that the trust owns that LLC interest, depending on the structure of that business. I mean, that can vary. Or at least coordinating those beneficiary designations to point it to the trust, on things like an IRA or maybe life insurance, so that it still points it where it needs to go. That is something that's really important to make sure that the plan actually works. Same thing, like a will only controls what's going through probate. A trust only controls what it owns when the person passes. So if it doesn't own anything, or nothing was designated to it as a beneficiary, that means it's a very well drafted potentially, but very expensive document that is essentially worthless to the estate then. So you want to make sure that you are properly coordinating your assets. And for example, that's something that we do for our clients because it is sometimes not something that somebody is used to doing, or there's very specific ways that you need to designate things. So it's not something you have to do on your own necessarily. But it is essential to making sure that the plan actually works. And then, kind of the one big thing with a trust as well is making sure that, if there are any concerns about, taxable planning or anything like that, trusts tend to give you a better way to do that taxable planning than in somebody's will, for example, or just using beneficiary designations. A well-drafted trust will allow someone to allocate certain assets to some, one beneficiary over another so that, it's the most tax efficient planning possible. Maybe you have one son that's a neurosurgeon and one son that's, kind of just maybe he's a starving artist, right? Something like that, and isn't making a lot of income. That might mean you want to allow for that trustee to maybe allocate any taxable income, something from an IRA, for example, to the child with a lower income bracket than the neurosurgeon who is probably in the top bracket. So you want those sort of flexibilities built into your plan as well. Okay, and I'm going a little over time here, so I will end there, but this topic is obviously, there's a lot of different things you can talk about with it, and I could go on for probably another hour if I needed to, but if you guys have any questions that came up from this that you would like us to address and talk with you about, please feel free to fill out that feedback form and let us know you'd like to set up an initial consultation. Again, those are complimentary, so you're not going to be charged to come in and talk to us. If you have any suggestions about topics or more specific topics you'd like to hear about, please let us know. But otherwise, join us next week to learn a little bit more about common mistakes that people make as caregivers for someone before they need any form of long-term care. Otherwise, enjoy the rest of your week, and